President Trump's attempts to interfere in the midterm elections. Following a series of false claims about voting from the president, a draft executive order is being pitched to the White House that would give the president extraordinary power over voting, a move that could violate the Constitution. Chief White House correspondent Mary Bruce has the details. Good morning, Mary.
Good morning, George. Well, we know that the president is considering mandating stricter voting rules ahead of the midterms, and now we have learned that the president has reviewed this draft executive order, which would declare a national emergency, then giving him sweeping power over voting. Sources say a group of pro-Trump attorneys are urging the president to sign this 17-page draft order, which claims without evidence that China interfered in the 2020 election, arguing that that then justifies declaring a national emergency that would then allow the president to mandate voter ID, hand-counted ballots, and ban mail-in ballots. Now, it's not clear if the president is actually going to act on this proposal, but he has reviewed it, and we do know that he is considering taking executive action, posting recently, quote, "There will be voter ID for the midterm elections, whether approved by Congress or not."
Hey everyone, DR John here. So what just happened, guys? While everyone watches the Iran war and impeachment drama, a quieter but equally consequential battle is being fought in federal courtrooms over voter registration rules, mail-in ballots, and election funding. No missiles, no viral explosions, just fine print.
Again, George, the Constitution gives states, not the president or the federal government, the power to run elections.
Right, Mary. And another part of this campaign, the DOJ is suing 5 more states.
Yeah, George, the list is now growing. The Justice Department now suing 5 more states for failing to hand over their full voter registration list. That brings the total number of states being sued to 29, plus the District of Columbia. Now, states have been pushing back against these demands, citing, among other things, serious concerns about voter privacy. And all of this is coming as the president continues to keep up that steady drumbeat of misinformation about voter fraud and continues to spread, without evidence, those false claims that he won the 2020 election, George.
But this fight will determine the actual shape of American democracy going forward. And like everything else with this administration, it didn't start with legislation or compromise. It started with an executive order designed to blow the whole system up. The instrument of this chaos was Executive Order 14248. Signed with the flourish of a man who believes the Oval Office comes with a magic wand, this order was nothing less than a unilateral attempt to restructure the foundational architecture of federal elections.
And in that context, I made it clear I did not agree with the idea of saying the election was stolen and putting out this stuff, which I told the president was and, I didn't want to be a part of it. And that's one of the reasons that went into me deciding to leave when I did. I observed, I think it was on December 1st, that, how can you can't live in a world where the incumbent administration stays in power based on its view, unsupported by specific evidence, that there was fraud in the election.
Hi again, everybody. How bad is it? It's so bad that we're going to call that point A. Okay. And we all know what Bill Barr's record was as Attorney General. But because of statements like that and testimony like that, that was before the January 6th Select Committee. Point A represents the safe and secure presidential elections, national elections we have enjoyed in our country without interruption over the course of this century.
It was a sprawling, ambitious, and constitutionally audacious document that sought to impose a rigid, nationwide framework dictated entirely by the whims of the White House. The order demanded that states adopt stringent proof of citizenship requirements tied to every federal voter registration form. It instructed the Department of Defense and other agencies to narrow the acceptance window for mail-in ballots.
And then point Z. That is the nightmare scenario. A president who has already exhibited a willingness and interest and effort to disrupt the peaceful transfer of power, encouraging violence if it's necessary, with an unfettered control over our election systems. It is difficult to pinpoint precisely where we are today, right now, this hour, on that sliding scale between A and Z. But this afternoon's developments make it abundantly clear we are straying further and further from point A and lurching ever closer and closer to point Z. The latest reporting from MS Now, quote, Donald Trump has directed his White House counsel's office to explore the feasibility of an executive order requiring proof of citizenship for voter registration
in ways that every election administrator in the country knew would lead to mass disenfranchisement. And, in a move that reeked of old-school, brass-knuckle political coercion, it threatened to sever the flow of federal election funding to any state that refused to kneel and adopt the president's preferred rules.
And photo identification at polling locations nationwide, even as his own lawyers have warned the moves would likely run into legal trouble, according to a senior White House official who spoke anonymously. Office of Management and Budget Director Russ Vought and White House Staff Secretary Will Scharf are among those overseeing the effort to determine whether a legally viable path forward on this stuff exists. It is the latest sign that Donald Trump intends to reshape American elections and unilaterally and without congressional buy-in test the limits of his executive authority. The only part of that is more chilling than the idea of a unilateral executive order that could disenfranchise a large number of American voters with the stroke of a pen, was that phrase toward the end of the reporting, quote, the latest sign, because it is, as we've been chronicling here, just a piece.
The ink was barely dry on the signature before voting rights organizations and a coalition of Democratic state attorneys general descended upon the federal courts with a unified, furious roar. They labeled the order exactly what it was, a blueprint for voter suppression dressed up in the hollow, fear-mongering language of election security. And the courts, from the district level on up, have been methodically, ruthlessly, and unanimously taking a sledgehammer to every single pillar of this scheme.
Albeit a very important one, of that drift ever closer to point Z on the spectrum. Case in point, brand new reporting in the Washington Post out late this afternoon, quote, pro-Trump activists who say they're in coordination with the White House are circulating a 17-page draft executive order that claims China interfered in the 2020 election as a basis to declare a national emergency that would unlock extraordinary presidential power over voting. Donald Trump has repeatedly previewed a plan to mandate voter ID and to ban mail-in ballots in November's midterm elections. The activists expect their draft will figure into Trump's promised executive order on the issue. The White House declined to elaborate on Trump's plans. Considering those two pieces of reporting from today as a pair, you can ask yourself, in our nation's 250-year history, have there been 250 days more important to the health and well-being and survival of our democracy than the span between this afternoon and Election Day? Because Point Z is calling, and we might be closer to it than you think. That's where we start the hour. With me at the table, senior White House reporter Vaughn Hilliard, who's bylined on that reporting we read from. Also joining us, president of the Brennan Center for Justice at NYU Law, Michael Waldman, is here. With me at the table, Democratic strategist and Columbia University professor, MS Now political analyst Basil Smikle is here, and Michael Feinberg is still with us as well. Vaughn, take me behind your reporting.
The first major blow landed with the force of a judicial freight train when a federal judge issued a sweeping nationwide injunction that froze the entire overhaul in its tracks. The ruling was a masterclass in constitutional clarity, siding with the attorneys general who argued that the President of the United States simply does not possess the authority to dictate the terms of federal elections by fiat. The gavel came down, and the message was clear. This is not how the republic works. But the administration, fueled by a combination of ideological zeal and the desperate political need to keep the election integrity base motivated, did not retreat. They pushed forward with the remaining unblessed components of the order, and the judiciary responded with the cold, hard efficiency of a well-oiled machine. In a subsequent ruling that sent shockwaves through state capitals, a federal judge specifically barred the administration from withholding election funds from states that were refusing to play ball. The judge looked at the administration's attempt to use the federal purse as a cudgel to force policy changes on sovereign states and called it what it was, a blatant textbook violation of the separation of powers and a direct assault on states' rights. And then, as if to remove any remaining doubt about the judiciary's view of this executive power grab, yet another federal court stepped in to dismantle the provisions that would have forced the Pentagon and other federal agencies to impose invasive citizenship screenings on military personnel and overseas voters before they could even receive a registration form. What we are witnessing is the application of a consistent, unwavering constitutional principle across multiple jurisdictions and multiple judicial appointments. The courts are speaking with one voice, and that voice is echoing the text of the Constitution itself. The authority to regulate the time, place, and manner of federal elections is not a toy that the founders left lying around the Oval Office for any president to pick up and play with. That power is explicitly, deliberately, and exclusively vested in the Congress of the United States, and, in the absence of congressional action, in the individual legislatures of the several states. The president has no constitutionally defined role to play in running elections. Zero. Zilch. Nada. You cannot change the rules of the democratic game simply because you have a Sharpie and a grievance about how the last one turned out. This is the judicial doctrine that the lower courts have been refining and articulating in opinion after scathing opinion. And it is this very doctrine, the one that puts a hard stop to presidential electioneering, that Trump's legal brain trust is now desperately trying to kick up the appellate ladder toward the one forum where they believe the rules of gravity might be suspended, the Supreme Court of the United States. Let us be precise about the current state of play. The headlines are accurate in their trajectory, even if the final act has not yet been written. The blocking of this order has so far occurred at the lower federal court level. The Supreme Court has not yet issued a definitive final merits ruling on the entirety of the election order. But the logical and procedural pathway is as clear as a runway on a cloudless night. The lower courts are establishing the constitutional floor. Congress and the states control elections, not the president. The administration is appealing those losses, filing briefs that claim the unitary executive theory allows the president to direct all federal agency interactions with the voting public. The cases are climbing the marble steps, inching ever closer to the courtroom where 6 conservative justices hold the gavel. And that is precisely the judicial path that makes the framing of this story so acutely accurate. The lower courts are writing the first draft of history, but the Supreme Court is where the final binding chapter will be authored. This is a collision course set on a timer. The specific constitutional doctrine that the lower courts are applying with such devastating effect is the direct intellectual descendant of the same clear congressional authorization principle that the Supreme Court itself wielded to gut Trump's tariff ambitions. The courts are essentially saying, Mr. President, you are claiming a power of remarkable scope. You are claiming the right to fundamentally alter how millions of Americans access the ballot box. If you want to do that, you need to show us exactly where in the Constitution or federal statute you are getting that permission slip. And when the administration's lawyers stand up and point to vague assertions of executive power, the judges are looking at the Elections Clause of Article 1, Section 4, and they are shaking their heads. The text is not ambiguous. It gives the power to Congress. It does not give it to the executive. This is the direct collision between Trump's expansive, authoritarian, adjacent, unitary executive theory and the cold, hard text of the founding document. The theory posits that the president has absolute control over the entire executive branch and can direct it to implement his policy priorities across the board. Applied to elections, this theory would greenlight exactly what Trump tried, directing the Pentagon and the DOJ to impose citizenship hurdles and conditioning HHS grants on voting rule compliance. But the courts are slamming the door on this application. The Elections Clause is a firewall. Presidential authority, no matter how broadly you interpret Article 2, does not extend to unilaterally overriding the constitutional allocation of electoral power. The characterization of this order as an election stunt is not a piece of partisan hyperbole cooked up by a media consultant. It is the sober, professional assessment of the entire voting rights legal community. The briefs filed against this order document a clear, undeniable subtext. This was not primarily about fixing a broken system. It was about shaping the political battlefield for the midterms and beyond. It was about making it incrementally harder for specific demographic groups in specific blue-leaning states to register and to vote, all while allowing the president to stand at a podium and claim he was valiantly fighting the phantom menace of mass voter fraud. The fraud framing is the political sugarcoating on a very bitter pill. The specific operational mechanisms, the demand demand for specific types of documentary proof of citizenship that millions of eligible Americans simply do not have at their fingertips, the arbitrary restriction of mail ballots to a receipt deadline that ignores the reality of the Postal Service, the financial blackmail of states that value voter access over voter restriction. These are the precise surgical instruments of a suppression campaign. They are designed to subtract votes from the ledger. And here is the most cynical, yet analytically precise piece of the entire puzzle. The political payoff of this maneuver is calculated to occur even if the law gets tossed out in the end. This is the hallmark of a litigation designed to lose strategy. It is a form of political judo where the legal defeat is secondary to the behavioral and psychological impact achieved before the gavel falls. If the executive order succeeds in its primary mission of creating chaos, confusion, and fear among voters and election officials before it is ultimately struck down by a judge, the suppression effect has already occurred. A voter who hears that they need a special kind of ID they don't possess might simply not attempt to register. A state official facing the loss of millions in federal grants might preemptively change their mail ballot procedures to be more restrictive, just to be safe. The chilling effect is the actual operational goal. The legal victory for the administration would be a nice bonus, but the confusion is the prize. This is what separates a genuine attempt at election security from a political stunt. A real security measure is built to survive legal challenge. It is rooted in clear, pre-existing statutory authority granted by Congress. It is developed in consultation with the actual people who run elections, the secretaries of state and county clerks who know how this machinery works. It is calibrated to address a real, documented, proportionate threat, and it is rolled out with processes that minimize disruption to legitimate voters. The executive order in question failed every single one of those tests. It was a legal grenade tossed into the machinery of democracy. So let us map out the terrain we are about to cover in full. We are going to dissect the specific constitutional doctrine that the courts are wielding as a weapon against this order and explain precisely why it represents the same fatal legal flaw that killed the tariff scheme. We are going to drill down into the granular mechanics of the order itself, the proof of citizenship hurdle, the mail ballot trap, the funding coercion, the military voter irony, and explain why voting rights lawyers view them as suppression tools rather than security enhancements. And, most importantly, we are going to gaze up the appellate ladder and forecast what the Supreme Court's eventual engagement with these cases will mean for the electoral environment and the broader existential war between the unitary executive theory and the constitutional framework that is designed to contain it. Let's begin where all constitutional analysis of election law must begin. The Elections Clause, Article 1, Section 4 of the United States Constitution, is the specific textual anchor that the lower courts are using to hold this presidency in check. It is a marvel of concise, structural allocation of power. It states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. Read that again. The state legislatures have primary authority. Congress has the ultimate oversight and override authority. Where in that sentence do you see the words president, executive, or commander-in-chief? You do not see them. They are absent. And that absence is not a drafting error. It is a feature, not a bug. The framers of the Constitution were students of history, particularly the history of how republics die. They knew, with a cold, hard certainty, that allowing the executive branch, the branch that holds the sword and commands the armies, to also control the mechanics of how that executive gets elected or re-elected is a recipe for autocracy. If the person in power gets to write the rules for how they stay in power, the game is over. The constitutional allocation of election authority to Congress and the states was an essential, structural safeguard designed precisely to prevent this concentration of electoral power in executive hands. Trump's executive order was a brazen, unprecedented claim of presidential authority to override this exact constitutional allocation. It was an attempt to use the levers of the federal bureaucracy, the DOJ, the Pentagon, the Department of Health and Human Services, to impose a uniform set of restrictive voting rules without ever setting foot in the Capitol to ask for a law. The order essentially claimed that the president can use his power to direct executive agencies to reshape the federal election infrastructure by fiat. And the lower courts, applying the clear constitutional authority test, have found that claim to be utterly and completely weightless. The president cannot use his incidental authority over federal forms to do something the Constitution explicitly reserves to another branch of government. You cannot use the back door of the Pentagon's mailroom to rewrite the front door of the polling place. This is the same constitutional logic that underpinned the tariff defeat. Claims of executive authority that are remarkable in their scope and consequence require a clear, unmistakable grant of power from the Constitution or Congress. And when it comes to elections, that grant of power went to the legislature, not the executive. Now let's zoom in on the specific mechanisms of the order, because this is where the voter suppression label moves from rhetoric to documented reality. First, the proof of citizenship requirement. Under the existing statutory framework of the National Voter Registration Act, a prospective voter using the federal mail-in registration form can attest to their citizenship under the solemn penalty of perjury. You sign your name, you swear you are a citizen, and you are registered. This system of attestation has been the standard functional mechanism for federal registration for decades. Trump's order sought to torch this system and replace it with a requirement for documentary proof. This sounds reasonable only if you have never worked in a county elections office or helped a low-income senior citizen navigate the bureaucracy of vital records. The specific kinds of documents required to prove citizenship are not universally held. Millions of eligible American citizens, people born at home in rural areas before birth certificates were standardized, people whose birth certificates contain clerical errors that require expensive court orders to fix, married women whose legal names don't match the name on their birth certificate, people displaced by poverty or natural disasters who have lost their papers. All of these people are citizens. They have the right to vote. A documentary proof requirement does not identify the infinitesimally small number of non-citizens attempting to vote illegally. It functions as an administrative wall that disproportionately blocks eligible citizens who are poor, elderly, or simply administratively unlucky. The mail ballot restriction. The order sought to limit the counting of mail ballots to those physically received by Election Day, rather than those postmarked by Election Day. This is a classic trap for the unwary. In a nation where postal delivery in rural communities can take a week to go 10 miles, this rule ensures that a voter who carefully mails their ballot on the Friday before the election might have their vote thrown in the garbage simply because the truck broke down in Cheyenne. It is a mechanism that creates arbitrary disenfranchisement based on geography and postal efficiency, factors entirely outside the voter's control. The funding conditioning mechanism. This was the blunt instrument wielded by Judge Chun in a pivotal ruling. The order attempted to condition federal election security grants on state adoption of Trump's rules. This is coercive federalism at its most naked. It is using the power of the federal checkbook to force sovereign states to change their laws without a vote of Congress. The Supreme Court's spending clause jurisprudence has long held that conditions on federal funds must be related to the program's purpose, must not be coercive to the point of compulsion, and must be clearly stated up front. Threatening to pull all election funding because a state allows ballot drop boxes is not a legitimate condition. It is extortion. And finally, the piece de resistance of ironic overreach, the military and overseas voter provision. The order directed the Pentagon to impose new, stringent citizenship documentation checks on the registration forms used by soldiers deployed overseas and Americans living abroad. The federal law that governs these voters, the Uniformed and Overseas Citizens Absentee Voting Act, was specifically written to make voting easier for these populations, recognizing that they face unique hurdles in getting mail and accessing government offices. By imposing new bureaucratic hoops for soldiers to jump through, the order revealed its true nature. It was not about securing the vote. It was about creating friction. It was about making the process harder for as many people as possible. And the fact that it ensnared military voters, the one group that the administration reflexively claims to revere, demonstrates that the underlying ideology is one of restriction for restriction's sake. The Supreme Court trajectory is the final looming shadow over all of this. The administration is not appealing these losses because they think they will win at the appellate level based on current precedent. They are appealing to get in front of the 6 conservative justices. The specific doctrinal question that will eventually land on the Chief Justice's desk is monumental. Does the president's authority over executive agencies extend to directing those agencies to reshape the federal federal election infrastructure in a way that overrides the constitutional allocation of authority to Congress and the states? The lower courts have said no with remarkable consistency, but the Roberts Court's track record on the clear congressional authorization principle is the wild card. If the court applies the same standard it used to gut the trade tariffs to this election power grab, the order is dead on arrival. The constitutional logic is identical. Both are claims of vast, unenumerated power. Both lack explicit statutory backing, but the court is also unpredictable, and the conservative majority has shown a willingness to entertain robust theories of executive power. The 2026 midterm environment is the high-stakes poker table where all these chips are being pushed. The order was designed to fog the battlefield, to make the act of voting feel risky, complicated, and uncertain for the voters most likely to oppose the president. The courts, moving with uncharacteristic speed and unanimity, have managed to lift much of that fog. The injunctions have provided clarity to state officials and voters. The suppression effect has been blunted, though not entirely eliminated, but the pending appeal to the Supreme Court keeps a sword of Damocles hanging over the entire process. The mere possibility that the court might reverse the lower courts and greenlight some version of this scheme is enough to keep state legislatures on edge and to fuel the fundraising emails of both parties. The continued litigation is the political value. It keeps the base angry. It keeps the issue alive. Even a loss at the Supreme Court can be spun as evidence of a rigged system, which is, of course, the ultimate goal of the entire stunt from the beginning. He tried to rewrite the election rules with a pen and a phone. The Constitution, through the voice of the federal judiciary, reminded him that the power to set those rules belongs to the people's representatives in Congress and their state capitals, not to one man in the West Wing. The courts have spoken repeatedly. The Supreme Court is waiting in the wings, and the same constitutional firewall that burned his trade agenda to the ground is glowing hot, ready for the next round of this desperate anti-democratic gambit.